My Lord, my ladies, on December 3rd, 2025, Vodafone Kenya, the 8th respondent, announced its intention to acquire the government's 15% stake in Safaricom PLC. And on December 4th, National Treasury tabled sessional paper number 3 of 2025, proposing partial divestiture over the over 6 billion shares. The court issued an order directing that the status quo be maintained pending determination of this application. Of critical point, my Lord, my ladies, for you to note is that despite the court's explicit order of 23rd March 2026, the National Assembly approved the sale to take effect on the 1st of April. A direct contravention of this court's authority. And an abuse and disregard to this court. My Lord, my ladies, the government proposes to sell at 34 Kenya shillings share against a prevailing market price of over 80 shillings per share. And during the substantive hearing of the petition, we will be able to prove this fact. The undervaluation represents a loss of approximately 250 billion Kenya shillings to the Kenyan public. 250 billion, my Lord, undervaluation. The sessional paper does not specify with precision how the proceeds will be applied. My Lord, my ladies, revenue sharing, revenue raising, I beg your pardon, through asset sale, this particular one as proposed, contravenes Article 209 of the Constitution, which limits revenue measures to taxes, to charges, and debts only. And that this goes to the consolidated fund. That is the way this country has been doing business since we became independent. I perhaps need to mention that this matter of infrastructure fund, sovereign fund, whatever, is also subject to litigation. But I wanted your Lordship and ladies to please take note of the gravity of this contravention of our Constitution, and particularly at Article 209. The legal framework, my Lord, my ladies, mainly the conservative orders, conservatory orders, are a constitutional remedy under Article 23 of the Constitution, not ordinary civil injunctions. And we proffered, I think, through the submissions, 3 definitive authorities which govern their grant. The first is Gitarau Peter Munya versus Dixon Mwenda Kigenji, very often quoted, 2014 Kenya Law Reports. It's a decision of the Supreme Court. Say the conservatory orders are granted on the inherent merit of the case, bearing in mind public interest, and I want to stress public interest, my Lord, my ladies, constitutional value, proportionate magnitude, and priority levels. Not merely the private party tests of irreparable harm. Number two, my lord, my ladies, Invesco Insurance Company Limited versus MW Minor 2016 Kenya Law Reports, where it was ruled that a conservatory order is an order of status quo. A judicial undertaking that no action of any kind is taken to preserve the subject until the suit is heard. The third authority, my lord and ladies, is that of Judicial Service Commission versus the Speaker of the National Assembly, 2013 Kenya Law Reports. And our submission, my lord, is all the three limbs are satisfied. Number one, public interest. Safaricom PLC is a strategic national asset holding the data of millions of Kenyans. And our submission is that handing it to a foreign entity compromises even our digital sovereignty. Rushed, opaque, and non-competitive, with no public participation for either the transaction or the session of paper itself. My lord, my ladies, Supreme Court in British American Tobacco PLC versus CS Minister of Health, 2019 Kenya Law Reports, held that public participation must be genuine, must be clear, must be comprehensive and inclusive, none of which was observed here. And my learned brother John Ohanga, when he talks of recognizing mischief, we truly do in this matter. The second limb is that on constitutional values. The impugned transaction violates Articles 1, 2, 10, 73, 75, 201, 206, 209, and 227 of this country's constitution. A document I can tell you, my lord, my ladies, I personally value, because we fought for this. And Kenyans have a document that keeps us together. At Article 10, Sub-Article 2, enshrines the rule of law, public participation, good governance, transparency, accountability, and integrity, all of which, in our humble submission, are absent here. As mentioned earlier, Article 209 expressly limits revenue raising to taxes, charges, and debts, as well as asset disposal. Asset disposal is not an authorized mode. The process was designed to be vague, opaque, shielding fundamental issues from public scrutiny. The third limb, so that I'm within the 30 minutes, Your Honor, Your Lord and my ladies, proportionate magnitude. The scale of constitutional violations involving a Kenya shillings 250 billion public loss, loss of data, sovereignty, and contempt, coupled with contempt of this court, is indeed grave and will be irreversible if this administration is allowed to continue with this transaction. The public interest in preserving the Constitution far outweighs the government's argument that it will realize 240 billion from this sale, or giving away 250 billion on the other hand. And one can only imagine what are the underhand negotiations. Even in public administration, the rule of law is paramount. Fiscal justifications cannot override constitutional imperatives. My lord, my ladies, allowing this sale to proceed will render the main petition nugatory and cause harm that cannot be undone by any future court order. And I see my friends, the respondents, in a hurry to get these things lifted so they can make their kill and leave Kenyans hanging high and dry. Allowing this to proceed, my lordship and ladies, will cause grave economic injustice to our country. All those Safaricom users, all those M-Pesas, as we said last time, a Kenyan invention of global recognition, just gets sold off. As to the matter of raising a prima facie case before the grant of conservatory orders, one has to, of course, highlight the possibility that you have an arguable constitutional issue or issues that are established. And the standard was set in MRAO versus First American Bank of Kenya, a 2003 Kenya law reports, and affirmed in David D. and others versus the Attorney General in 2021 Kenya law reports. A prima facie case is not one that must succeed, but one that is genuine, arguable, and discloses a right apparently infringed.